Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to talk about concealed carry, more specifically, concealed carry reciprocity, more specifically, some of these states that literally do not honor a person's Second Amendment right unless you happen to be a resident of that state. You know, there is no other right. Your right to be free from unreasonable government searches and seizures, your right to speak freely, your right for religious freedoms. None of those other rights disappear when you cross the state line. But when it comes to the Second Amendment inalienable right of self-preservation, for some reason, there are some states where, come hell or high water, you will never, ever, ever be able to carry in that state unless you're a resident, and even then you're going to be lucky to carry that. We're going to talk about a new case that was filed, which I think is part of this much larger eye-opening experience that we're going to have as it relates to national concealed carry reciprocity, especially in light of the mandates of the Bruin opinion. This is the second case filed. It's clear on the other side of the country, and I'm more excited about this one than I even was on the first one. So today, let's spend a few minutes and let's talk about another huge case for national concealed carry. Okay, so the case we're talking about today is a case called Higbie v. James. It is filed in the United States District Court for the Northern District of New York. It is brought to us by our good friends at the Gun Owners of America. This is a challenge to New York's crazy scheme where only those who happen to be in-state residents might somehow win a lottery once in a while and actually get a concealed carry license. If you are from out of state or visiting from out of state, there is no way on God's green earth at all, ever, you will be able to lawfully carry a firearm on your person. The same problem persists in California. The same problem persists in Hawaii, too. Kevin O'Grady, you might want to start warming your pleadings up. To give you an idea, and I will tell you that this is really an area that I'm very excited about. I think in the post-Bruin world, what we're looking at is some real enlightenment on a few issues. One of it is cannabis and those who possess firearms, cannabis users and those who possess firearms. Secondly, non-violent felons. I think that we're going to have a real reawakening on that. And this third issue, the issue that we're talking about today, is concealed carry reciprocity for the exact reasons that you don't lose any other constitutional right by merely crossing a state line. Now, to give you an idea exactly where the plaintiffs are coming from on this, their pleading state. First, New York does not recognize or grant reciprocity to any concealed carry permit issued by any other state. Whereas someone from Massachusetts can drive into New York based on a Massachusetts driver's license, the same Massachusetts citizen cannot carry a firearm into New York based on a Massachusetts concealed carry license. Let me also point out that only one of those two is actually guaranteed by the Constitution, and it's not driving a car. Plaintiffs also state, second, New York does not allow non-New York residents who do not own property in New York even to apply for a New York firearm permit, instead allowing only New York residents and some individuals who satisfy various exceptions not relevant here to apply. Third, because New York does not permit a person even to possess most firearms without a permit, the inability of non-residents to obtain a New York permit means they cannot even keep arms even within a private domicile or on private property. And because New York does not permit the open carry of firearms, there is no way for non-residents to bear arms in public without a permit or reciprocity. And so what does this lead to? Well, the plaintiffs pointed out. Thus, for the 94% of Americans who are not residents of New York, the right to keep and bear arms in public simply does not exist within the state. No other provision of the Bill of Rights works this way. And listen, this whole concept of not permitting individuals who've been vetted by one state, passed all of qualifications of one state, to not carry into another state, especially an adjoining state, has led to incredibly absurd results. Let us remember the case we talked about of Commonwealth v. Donnell, a case, by the way, that was actually cited by the plaintiffs in their pleadings. As one court recently concluded, a law-abiding resident of one state who is exercising his constitutional right should not become a felon by exercising that right while he is traveling through another state merely because he has not obtained that state's license to carry. This court can think of no other constitutional right which a person loses simply by traveling beyond his home state's borders into another state, continuing to exercise that right, and instantaneously becomes a felon. Now, anytime we're going to analyze the constitutionality of a gun regulation, we're going to run it through a Bruin test. Now, I have tried to explain the Bruin test in very simple English. I think I've done a pretty good job. I will tell you that I found a paragraph in this pleading that I think really sums up the Bruin test perfectly, and it reads as follows. In other words, according to the Second Amendment's text, and as elucidated by the court in Bruin, if a member of the people wishes to keep or bear a protected arm, then the ability to do so shall not be infringed, period. There are no ifs, ands, or buts, and it does not matter, even a little bit, how important, significant, compelling, or overriding the government's justification for or interest in infringing the right. It does not matter whether a government restriction minimally versus severely burdens the Second Amendment. There are no relevant statistical studies to be consulted. There are no sociological arguments to be considered. The ubiquitous problem of crime or the density of population do not affect the equation. The only appropriate inquiry then, according to Bruin, is what the public understanding of the right to keep and bear arms was during the ratification of the Second Amendment in 1791. That is an absolutely perfectly worded summation of what the Bruin opinion is. Of course, there is no historical tradition at all whatsoever, and I know New York is going to try with all of the crazy Bowie knife laws and disarmament laws for loyalists and all of that kind of stuff. But there is no historical precedent that's going to support this law. Ultimately, the plaintiffs point out, because New York law operates to entirely deprive non-residents of Second Amendment rights, this court's intervention is necessary to make it clear to New York that it is not free to thumb its nose at the text of the Second Amendment, the opinions of the Supreme Court, and that the Second Amendment is neither a constitutional orphan nor a second-class right. Now, in addition to the obvious Second Amendment claims that are occurring here, there is also an additional argument, and we saw this also in the California case as well, is that, hey, listen, under the full faith and credit, under the Privileges and Immunities Clause of the federal Constitution, states have to honor the licensing and court orders of other states. As the plaintiffs put it here, the full faith and credit clause of the U.S. Constitution provides that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, recordings, and proceedings shall be proved to the effect thereof. New York's refusal to grant reciprocity to any out-of-state permits violates the full faith and credit New York must give to the permits of other states. New York's statutory scheme, which refuses to accept, honor, or acknowledge permits issued to the citizens of other states, like plaintiffs, violates this constitutional provision. So ultimately here, the plaintiffs are claiming two separate causes of actions. Both of them are under 42 United States Code Section 1983. Now, for those of us who geeked out in law school, we all know what a 1983 claim is. In a nutshell, it is the deprivation of a constitutional right which is being inflicted by color of state law. That is, state government acting in accordance with the law is actually thwarting or violating a constitutional right. There are two separate grounds: that the state of New York is violating an individual's Second Amendment rights, which is true. The second cause of action is that the state of New York is violating the Privileges and Immunities Clause or the full faith and credit of the federal Constitution. That is also true. The case, once again, is Higbie v. James. We'll link it up down below so that you guys can geek out on the opening pleadings. Listen, I think this is a fascinating area that we are just now beginning to kind of peel open, and there's going to be a lot more. We're going to carefully watch California Rifle and Pistol Association v. Luna out on the West Coast. We're going to have to carefully watch this case, Higbie v. James, out on the East Coast. Kevin O'Grady, you guys in Hawaii need to crank up your pleadings now so we can watch that one out there as well. Listen, if you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box as well. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.